Let's go ahead and get started. Welcome, everybody. My name is Galia Schmidt. I am the owner and lead attorney at Aharoni Business Law. We're a business, employment, and intellectual property firm based out of Oakland, California. I am here happily alongside with the San Francisco LGBT Center and a wonderful organization called StartSmall, ThinkBig. Thank you to both of you for inviting me and including me in this. I will address the weird elephant in the room, that it's super weird that we're sitting around talking about contracts while there's a crazy pandemic going on and everyone is very stressed out and worried and busy. So thank you for being here, and thank you for watching this if you're watching online later. I do think that contracts is still actually a really important thing for everyone to be thinking about right now, and it is really timely. A lot of people are going to be unable to fulfill promises they've made, frankly, over the next month or two. And I think we're going to have to see how that plays out over time. And knowing a little bit about how contracts work is going to be really important coming up, whether you're the one that feels like you can't fulfill yours or whether you're in a contract with someone who might not be able to fulfill their promise to you. For example, I'm already getting calls about people being unable to pay their rent on a commercial lease, or they are putting on an event that people have already paid for but may have to cancel the event. Things like that are going to be happening a lot, unfortunately. So there is a lot of content in this one and a lot of legal stuff, but we'll try to make everything as interesting as possible. And I am open to getting questions throughout. If you have questions as we go, I'll keep an eye on the Q&A box, so stick those in the Q&A box. And Eddie and Joe, you can also interrupt me if you see good questions or you have questions of your own that I think we should address. So before we jump into the content, I'm going to have Eddie and Joe introduce themselves and tell us a little bit about their organization. So Eddie, I'm going to hand it over to you to talk about the LGBT Center.
Oh, great. Thank you, Galia. Hi, I'm Eddie. I'm the small business consultant at the San Francisco LGBT Center. I run the small business program at the center. The core service, we're here to support the LGBTQI run small business owners. The core of our service is one-on-one business consulting, but we also do bi-weekly business incubator drop-in session, which we have stopped for the next few weeks because of the what's going on right now. And we also do business workshop, which we sometimes partner with StartSmall, ThinkBig. We offer a wide range of small business workshop, including legal, marketing, business plan, finance, and all that. We also host a twice a year market fair to showcase LGBT-run small business, which will probably also not happening this year for June. For June, yeah, we're planning to have it for June, but I think it will be very difficult to plan for this right now. The other thing I want to mention to people that's listening right now is that there are a few programs that currently the government, federal government and state government, as well as the city, is offering to help small business owner, including a disaster assistance loan that's offering by SBA that provides repayment period for up to 30 years. And there is also up to $10,000 grant that's offering by the mayor's office. If you wanted to know more about these two programs and how to apply for them, you're welcome to email me. My email is sbconsultant@sfcenter.org. Oh yeah, it's on the screen. Or you can call me. These two programs are coming really handy for small business owners, that if you actually see a significant drop in your revenue because of the situation and you cannot meet your current obligation. So yeah, it's a good time to, and also we are, at the center, we are currently offering a one-on-one meeting for both new clients and existing clients online. So don't hesitate to contact me, and we can set up a meeting to talk to you about your challenges online. Thank you.
Thanks so much, Eddie. It's really good to know how valuable of a resource you are going to be in this time. And we can follow up again at the end with more contact info and talking again about resources maybe. So Joe, I'm gonna send it over to you to talk about StartSmall, ThinkBig for a minute.
Good. Hi, everybody. I'm Joe Willer, and I am the Bay Area Legal Program Manager for StartSmall, ThinkBig. We are a nonprofit organization that offers legal, financial, and marketing assistance to low to moderate income entrepreneurs. We operate in New York City and the Bay Area, and just recently opened an office in San Jose. So if you're in any of those areas, feel free to apply online. There's more information about that to come, and we're happy to serve as many people as we can. Sorry, could you step back for a second? We do have a few eligibility requirements that I want to touch on before we move forward. First is that we work with businesses that are already operating, even if just in a small amount of sales. So our requirement there is that you have at least $500 of sales in the last 3 months. We do have some legal carve-outs for businesses that can't generate any revenue until they have a particular legal need met. That can be things like, hypothetically, a daycare center can't generate any revenue until they have signed a commercial lease that gives them space to be able to run that business. So additional eligibility requirements include income requirements and asset requirements. Basically, that means that if you have an income that is greater than 500% of the federal poverty guidelines, which for an individual works out to be about $63,000 in 2020, and it goes up with more members of your household, then you do not qualify. So we serve businesses that have owners that make less than 500% of the federal poverty guidelines. Additionally, we don't serve any businesses that have more than $50,000 in eligible assets. Those include cash on hand, as well as investments in stocks or mutual funds and things like that, as well as any equity that you have in a second home, like a vacation home or something like that. Specifically, it does not include any equity you have in your primary residence, as well as anything you have in retirement accounts. So that doesn't qualify. That doesn't count towards our $50,000 eligibility, asset eligibility cap. And additionally, we have some geographic requirements, meaning that you must be from, at least in California, Alameda County, Contra Costa County, San Francisco County, Santa Clara County, or San Mateo County. In New York, we serve all 5 boroughs, but I think that'll be somewhat less relevant to this audience. So next slide. We have 3 programs. As mentioned, we give legal, financial, and marketing services. Our legal program can help with things like entity formation, whether it's forming an LLC or forming corporation. We can explain the requirements for that, your responsibilities. If you own one of those entities, we can help draft contracts or review commercial leases, as well as some other helpful legal matters. The way this works is we match you with volunteer attorneys from some of the largest law firms in the area, and then they will form an attorney-client relationship with you and help you through that particular matter. Next slide. Our financial program is in-house out of New York City, so meetings with them will be remote for those in the Bay Area, and they can help with things like understanding financial statements, getting set up with your bookkeeping software, and keeping on top of the books. They can help set prices for things to make sure that you're covering all of your costs, as well as making enough to make the business worth your while. You can also help with projections and planning for your business. And then our market access program can help with things like developing a social media strategy. We sometimes have volunteer graphic designers that can help develop the brand of your business. We can audit your website, give you information about search engine optimization and other important parts of marketing your small business. And then, so here we have a link to our application online. It's bit.ly/SSTB app. You can also just navigate to our website at StartSmallThinkBig.org, and the button to apply is pretty easy to find on that page. If you have any questions, we have a program manager out here named Maura, and you can reach her at maura@startsmallthinkbig.org. And we also have a phone number there listed at the bottom. So if you have any questions, feel free to reach out to Maura or give a call to that number and leave a voicemail, and we will get back to you when we can. And with that, I'm going to turn it back to Galia, and she'll walk you through some of the substantive material that we have today.
Thanks so much, guys, and thanks again for being here. I know that you are going to be a valuable resource for my clients as well, so I'm very happy that people like you exist doing the work you're doing. So we can jump right in. First, I got to do the obligatory lawyer disclaimer. So this is not legal advice, et cetera, et cetera. Talk to a lawyer if you have questions about this. The other thing is that this is specifically about California law, primarily at least. So if there's another state that you are looking to get answers for your contracts, probably going to be similar, but don't rely on this as, don't assume it's true because you heard it here. So, so we can move forward knowing that. So this is kind of the agenda we're going to be working off of today. When we're going to talk about the elements of a contract. What is a contract? What makes something a contract or not? We're going to talk about common provisions that we usually see in contracts, and this is specifically, we're talking about business-related contracts here. Section 3, we'll talk about negotiation and drafting of those contracts. How does it work to create a contract? What are the steps? Next, we'll talk about breach, enforcement, and remedies. What happens if you cannot fulfill your obligations in a contract? What happens? Next, we'll talk about just some common types of contracts we see in businesses that I draft for people and that Joe probably sees a lot at Start Small, Think Big. And finally, just quick talk about the most common problems I see in contracts in my day-to-day working with small businesses. So we're going to start there. So number one, what is a contract? So this seems like a kind of obvious question, but we actually spend 2 semesters of law school learning about what a contract actually is. So we're going to start off with this definition here. A contract is an agreement between 2 or more parties creating obligations that are enforceable by law. So let's break that down a little bit. Agreement, I think we all can kind of understand what that means. More than one party, that means you can't have a binding contract with yourself. Obligations, we will talk about in a second, and enforceable by law we'll also talk about later on when we talk about breach. So basically, what's the point of a contract? Why do we have them, and why are they so regulated by law? What are some reasons it's helpful for us to talk about details in advance of doing something for someone else? So in my opinion, contracts are so useful because they minimize ambiguity. They put everything up front so everyone understands what everyone's job is and what happens in different scenarios. So I think a good contract, the goal should be to eliminate as much ambiguity as possible. We want it to be as clear as possible because the more ambiguity there is, the higher the likelihood is of conflict and confusion. And conflict and confusion leads not only to just stress and money, but lawsuits, and we want to avoid that. We don't want a judge to decide what our contract means. We want it to be super clear up front. So what makes something a contract? These are the 3 parts of a contract. 1, offer. 2, acceptance. And 3, consideration. So we're gonna go through each one of these. So what is an offer? An offer is a promise to act or refrain from acting made in exchange for a return promise. So let's break that down a little bit. So one thing that is asked a lot, how do you tell if something is a negotiation versus something is an offer? So negotiations really don't have the present intent to form a contract. It's really more like, let's have a conversation and figure out if this is something that we really want to do. And if so, we'll get to the point where we make an offer. An offer really is intending, I say this, if you say yes, it's a contract and we're done. So how does an offer work? An offer stays open until one of these things happens. So the first thing is acceptance. I say, hey, do you want to buy my car for $1,000? And you say, yeah, that's acceptance. And we'll talk more about acceptance too. But that's what, as soon as you accept, the offer is closed. The next one is withdrawal or revocation. So I say, do you want to buy my car for $1,000? And I later on say, never mind, I don't want to do that anymore. I'm taking it back. And if you haven't said yes yet, then I'm allowed to do that and the offer is off the table. You can revoke at any time before acceptance has happened. The next one is rejection. I say, do you want to buy my car for $1,000? And you say, nope, I'm good. That offer's closed. We can make more offers later, but that specific offer is closed, and they can't then come change their mind and say, oh yeah, I actually want it now. The next one is expiration. So expiration is, do you want to buy my car for $1,000? You have 24 hours to accept this offer. And if 24 hours goes by and I don't hear from you, then offer is gone, off the table. You can no longer accept that and make it a binding contract. And last, reasonable time. That would be me saying, you want to buy my car for $1,000. If I don't hear from you until a year later and you say, hey, I still want to buy that car, that's probably not going to be a reasonable amount of time. So that the reasonable time will come down to context and kind of what's going on. For some things, a year might be a reasonable amount of time. Most of the time, it's going to be a few days or a few weeks, right? Or sometimes even a few minutes. So it's kind of what a reasonable person would consider a sufficient amount of time under the circumstances. Other things that can close an offer, if I make you an offer and I die, that offer is off the table. Insanity or lack of capacity is another one. Destruction of the subject matter. If I offer you the car and then the car gets totaled, I don't have to, and then you say you want to buy it, I don't have to, the offer is canceled. I don't have to give you the car or give you a different car. And also, if there are conditions that happen that suddenly make this thing illegal, offer again is canceled. So you don't have to worry about it. So an option contract I also like to mention because option contracts are fairly popular. They also, especially around here in the Bay Area, you hear a lot of people talking about option contracts for stock and things like that. So really an offer contract is just kind of an agreement to agree. It's an agreement that says I'm allowed to accept the offer later instead of necessarily right now. So it generally makes the offer irrevocable during that time period. So I can have an option, let's say for 3 months to decide. And it kind of just holds your place in line and sometimes gives you first dibs on this thing. So it can be really useful if you're still negotiating or if you need time or if it's a really big thing like stock or something like that. That's another way to have an offer. So the next thing we're looking at here is acceptance. So I've given you the offer. What happens next? An acceptance is an unconditional expression of acceptance of the term. So again, let's break that down a little bit. The person who's receiving the offer has to know about the offer. I can't just kind of say it into the ether and then expect you to know that I've made you the offer. And then there has to be a visible, really clear, obvious acceptance with a very clear proof that you intend to be entering into a contract with me. It also has to be expressed without conditions, so unconditional expression. So if there's any changes made to the offer, it's no longer acceptance. And we'll talk about what that is instead on the next slide. So generally speaking, the acceptance has to happen in the same manner that the offer was made. So if I offer the car to you over the phone, you're probably going to call me back or talk to me in person, something like that. If it's not specified, sometimes you can say in the contract, you have to you have to accept by writing by such and such date, then you have to accept in whatever manner is specified, but any manner that's reasonable, really. If you call me, if you email me, if it's some way that I'm reasonably going to get it, and it's a normal way of communicating things like that in that situation, it's fine. You know, you can't force someone to rent a plane and do some skywriting or smoke signals to you. And oral, if an oral acceptance to a written offer is going to depend on the circumstances. So be careful. Usually, if it's a written offer, do a written acceptance. So let's see an example. So if I put a post on Craigslist and I say, I will give you $1,000 to come and paint my house, and I don't hear back. But then I wake up in the morning and find that my house has been painted and the painter is demanding money from me. Was that a valid acceptance, and do I have to pay this person? Probably not, because there was no actual clear expression of the acceptance of my terms before performance was made. So on that note, let's talk about counteroffer. So a counteroffer is an offer to do the deal, but on different terms that are different from the original offer. So, so if I say, I will sell you my car for $1,000, and you say, no, how about 500? That is not going to be an acceptance. That's going to be a counteroffer. Anytime you're coming back to me and saying, yes, but, or yes, if, then that's going to be a counteroffer, which then shifts the burden to the other person to accept. So the roles are now switched. So again, our Craigslist house painting thing, if I post it for $1,000 and they call me and they say, make it $1,500, is that an acceptance? No, that's a counteroffer. And it's up to me now whether to accept the new offer of $1,500. So let's do a quick pop quiz here. I say, I sell you my car for $200. Person B says, I'll buy it for $100. I then say, how about $150? We shake hands. You say, I'll see you tomorrow with the money, and then you show up with only $100 and are demanding that that you've changed your mind and it's only $100 now. So is there a contract here? And if so, at what point was a contract made? So so when I say I'll sell you my car for $200, no contract is made yet, right? That's just an offer. When person B says I'll buy it for $100, is that an acceptance? Probably not. It's changing the terms, right? It's not an unconditional acceptance. So now we have a counteroffer. So number 3, it goes back to me to decide whether, and so I then make another counteroffer and say, how about 150? And then we shake hands. So shaking hands in the circumstances is probably good enough to assume that everyone agrees that $150 has been accepted by both parties, and then that's affirmed by a person B saying, I'll see you tomorrow with the money. So a discussion has been made. This is a pretty clear and reasonable way to accept an offer. So that's the point where a contract has been made. Acceptance has been done, offer and acceptance. So if B arrives with $100, can A enforce against B? The answer is yes, because there's been a contract and B is now not fulfilling their part of the bargain. So that's how that would work in that situation. So the last element here to make something a contract is called consideration. And so this can also end up being this really deep minefield of nuance, but generally speaking, in a nutshell, consideration is each party has to give something of value to the other party. So it has to be on both sides. Each side is doing something, but it can be a promise to do something, or a promise not to do something, or a promise to give something. So basically, you can't just give something for nothing. Both parties have to be promising something. So if I offer to paint your house for you, and that's it, and you say yes, there's no consideration. It's not a contract. So I'm just doing you a favor. I'm painting your house. Or if you promise to paint my house for no consideration and you don't do it, there's really nothing I can do to make you do it because there is no consideration. So yeah, if there's no consideration, probably just a gift or it's a favor you were counting on, but you can't do anything to enforce it. So what are some examples here? Money is the main one, right? Usually somebody's paying money in exchange for services or goods. so every time we buy something, there's a contract involved. Employment is also a contract. We're promising work in exchange for money. But it can also just be promises. It can be a promise to do something or a promise not to do something. There just has to be some burden on both sides here. So let's do another little pop quiz. Rich uncle promises to give nephew a sports car if nephew refrains from smoking and drinking alcohol for 5 years. Is there consideration here? So the answer is yes on both sides, and this would be a contract. So uncle is making a promise to do something he doesn't otherwise have to do. He's promising to buy the kid a car. Nephew is making a promise not to do something he otherwise is legally entitled to do. So even though part of this is not doing something, and even though uncle isn't getting anything direct in his pocket, he's not getting money, he's not getting some direct benefit, there's still consideration because each party is promising to do something or to not do something. And that counts, a promise for a promise. So the last thing to mention here is also just competence. There are reasons when, even if there's offer acceptance and consideration, a contract still won't be good. So minors, for example, minors kind of, under 18, minors kind of can enter into contracts, but they call it voidable. So a minor can enter into a contract, like get a job, or a promise to do something or not do something. So let's say our nephew example, he was under 18. They are bound by that thing. But it is voidable, which means if the minor does something to say, actually, you know what, I'm disavowing this contract, I'm not going to do it, that minor won't be liable for breaching that contract. So it's kind of in this middle ground, and you don't really need to understand the nuance of that, but they kind of can enter contracts, but they can get out of a contract a lot easier than someone over 18. Incapacitation is also similar. If someone is not able to understand the nature and consequences of an agreement, it's also voidable. So if you can show that someone wasn't in the right mind for whatever reason and wasn't able to actually knowingly and consciously understand what they were signing up for, you might be able to cancel that contract. Or intoxication, again, voidable, but only if the other person knew that the person was impaired at the time. So if I'm selling my car for $1,000 to someone who's super drunk, but I can't tell, I might still be able to collect that money. But if I knew, then probably not. They could probably get out of it. So true or false? In order for a contract to be enforceable, it must be in writing. What do you think? So the answer is you can have oral contracts. Even very serious contracts can be oral. And so this is where people can accidentally enter into contracts sometimes, because you're just having a conversation and say, hey, how about we do blah? And the other person says, yeah, I'm in. That can still be a contract, and it can still be enforceable in court. So the thing is, there are a few types of contracts that do have to be in writing. The rule here is called the Statute of Frauds. You do not need to know that or understand it. Again, we spend a lot of time in law school learning about this, but generally, things like promises to pay debt, things like prenups, real estate transactions, and high value goods over like $500 are going to have to be in writing for it to be enforceable. And there are more than this in the state of California, but these are the big ones. So generally though, if it's going to be a serious contract, have it in writing, even if you don't have to, because it's, again, going to minimize ambiguity and really protect everybody in that situation. So why do we have written contracts even if we don't have to? First of all, it's just proof that this agreement existed. So it's a lot harder to prove a conversation that you had, especially if one person says we didn't have this conversation. If you have it in writing and everyone signed, that's clear proof, and you don't have to argue a he said, she said kind of thing. Proof of terms also, again, we have proof now that these are the things we agreed to. So if one person says I didn't agree to that, it's a lot easier to prove it if you have it written down with their signature on it. And again, it's just required sometimes to have it in writing. So I don't see any questions coming in, so let's take a breath though. That's what forms a contract. Next, let's talk about what are some common provisions that we see in business contracts that I work on with people. So the very first part is usually what we call the recitals. So I call these the whereases. This is the kind of top of the contract that's like, whereas Party A wants to do work for Party B, and whereas Party B has lots of experience doing such and such, Party A's A and B want to enter into this. So, the whereases usually are not legally binding, but they provide some really important context sometimes for what's going on and to set the stage for what the purpose of this contract is, which can help interpret the contract later if there's conflict. So although, a lot of contracts are not going to require these whereases at all, they can be really useful, and that's why they're in there. The next one is we often see a definition section. So again, this isn't in all contracts, but especially business contracts and long contracts and complex contracts, we see a lot of definitions in there. So sometimes it'll be a whole section that just defines all the terms that you're going to be using in the contract. And definitions can also just be throughout, which is also really common. But it can, again, be very useful, especially in complex legal documents, to have very specific definitions and even a section to just know you can look at. Definitions may or may not be binding. Usually it's going to be, because sometimes there's binding terms in there as well, and it's going to be really important for interpreting the contract later. Terms and services is the main thing. What are we doing? What are we promising to do or not do for each other? And depending on what the services are, this could be a half a sentence long thing, or it could be a multi-page long thing. But again, the more detail you have in there about what each party's obligation is, the less likely you're going to have conflicts later by one person saying, hey, no, I actually hired you to do X, Y, and Z. And you're like, no, you only hired me to do X, and so therefore you still got to pay me. That's going to really eliminate a lot of ambiguity here. And it's especially if you're the one doing performance. Let's say a web developer is designing a website for someone. You need to be really clear about what's included. How many pages? Are you doing SEO or are you not doing SEO? Are you including a blog or are you not including a blog? How many revisions are you including? All of these things are going to be very important, because if the client just decides they want more and more and more and more, you need to be able to say, no, you only are agreed to do this amount, and otherwise you need to just pay me more. So terms and services, very important. Payment, also very important. Again, this is one of the main things we make sure is really fleshed out in contracts we write for people. So especially in again, our kind of web developer example of performing services in exchange for money. So how much money is due? When is the money due? Is it going to be in installments? Is it up front? Is it at the end? Our web developer, maybe we want some money up front to secure the contract, some money in the middle, and some money at the end, because we also don't want to risk doing all the work and then the client decides not to pay you at the end. What happens if someone pays you late? What happens if you're halfway through the project and there's an installment payment due and they don't pay you? What are you supposed to do? Do you have to keep working? Are you allowed to stop until they pay you? And if they're late, are you allowed to charge interest? All of that has to be written in the contract, and those things happen all the time. And you don't want to be in a position, if you're the one doing the work, where you're not getting paid for the work you're doing. And that's unfortunately one of the most common things we see happen in contracts. People just don't pay. The next one is the term. How long does this last for? How do we know this is over? So sometimes, depending on what we're doing, if we're doing a website for someone, the contract's probably going to end when it's done and when final payment is made. But sometimes things like consulting can be kind of indefinite, or month to month or something like that. And we need to be clear about when it expires or doesn't expire, so we know when this contract ends. And termination, how does it end? Does it end automatically? What happens if we need to end it early? Under what circumstances can we end it early? Can I just say, I don't want to do this anymore, I'm going to stop? Or can we only cancel it for good reasons, like they stopped paying me, or they didn't perform, or something like that? Is there a question? Okay, so we need to be really specific about when we can end the contract early, and not only that, but what happens when we end the contract early. Does the person get their money back? Do they get partial money back? Because presumably, if I made half a website and then they cancel, I'm at least going to want to get paid for the work I've done so far. Maybe the consequences are different depending on if it was for cause or not for cause. Maybe if it's not for cause, they need to give me 30 days notice, so I have enough heads up to get another client in the meantime. So Another thing we're going to include in there is if someone cancels for cause, meaning they had a good reason, not just kind of on a whim, so they're not paying or the other person breached the contract, are we going to give them an opportunity to cure? So what that means is they've breached the contract. Do I give them an opportunity to fix the problem, or is the contract just over right when they breach? So am I going to let them pay late? Am I going to, if they've been not communicating with me in a way that they're supposed to communicate with me, am I going to give them a chance to undo that? If they've made a mistake, am I going to let them fix it, or is the contract just going to end? So all of those things are really important to put in here. And this termination clause I bolded because I think this is going to be a really big one that we're going to see fights about over the next few months, because a lot of people, I think, are going to be wanting to get out of contracts. And this termination clause is going to be a really big one to look at, to figure out under what circumstances we can get out of this contract, and what happens if we do. Do we give the money back? Do we give partial money back? Do we not owe anything at all? And we're going to have to go from there and see what happens. So hopefully people have written termination clauses, but this is exactly a good reason why we need to have good termination clauses in here, so we know what happens, because things do happen even if everyone has the best intentions. So there are, here's more. So other common provisions, especially in business contracts. So the first one here is intellectual property licensing or assignment. So basically, this just means we need to decide who owns what and at what point does who own what. So generally speaking, intellectual property is owned by the person who creates it, except for if someone's an employee or if they give it to them. So and IP has to be transferred in writing. So if we go back to our web developer example, the web developer creates a website that has copyright rights that have been created that the web developer owns. The web developer may not feel the need to own this and may be fine giving all the copyright rights over to their client. But in order to do that, it has to be done in writing in this contract. So a lot of people don't know that. Even people in creative industries don't know. And there's a whole bunch of IP, I think, floating around where some people think they own it and don't. And some people want to own it and don't, or own things that they don't feel like they need to own and that they thought they were making for their client. So it's important to know this and important to put it in a contract. If we're representing the creative person in a contract, one thing we will do is, if we're transferring the IP, we leave the transfer until final payment is done. So I, website developer, I'm going to own all of the copyright and other IP for this website until you give me final payment and you're totally paid in full and this contract ends. So that's another way to just provide incentive to get paid, because that, like I said, that's one of the main reasons we go wrong. Indemnification provisions. These are ones that scare a lot of people because it sounds like a scary word, but it's really not so scary if you understand how it works. So basically, indemnification, I just call this a "I got your back" clause. It's basically saying if we're in a contract and one of us gets sued, the other party might have to defend the opposing party in court to cover any damages that get awarded. So a really common way to do this is, let's say you and I have a contract and you do something negligent that causes someone else to sue you, but they're suing me too. You might have to be responsible for covering my legal fees and any damages that I might be on the hook for in that lawsuit because it was your fault, right? So it's basically saying, I got you. I'm going to cover you in court if I was responsible for this thing, but you are getting in trouble for it, basically. So we see these a lot. One thing we look out for is whether this indemnification clause is one way or if it's mutual. So if I'm representing somebody, I'm going to want the other party to indemnify my client. But if it's the other way around, I'm going to ask for mutual. I think the most fair thing is everybody indemnifies everybody. We all got each other's back. If it's not your fault, we're going to get you. But you do sometimes see one-way indemnification clauses where you're signing up to indemnify them, but they're not signing up to indemnify you. And that's something I would look for and push back on because you want it to be fair. The next one is limitations of liability. So this is one of the main things we do in our contracts. One of the main reasons to have a contract is to limit your liability, which just means limit the things that you are on the hook for in providing these services to someone. So the purpose is kind of to reduce or eliminate the potential for damages, whether that's money damages or penalties or indirect damages if somebody is breached. So you can waive specific things. You can say, I'm only going to be liable for these things like negligence or, you know, a faulty product, but not all this other stuff. And you can even put in dollar values. If I get sued for this, if you sue me, you can only collect up to $150,000 worth of value, or the value of this contract, or something like that. So we don't see dollar value caps a lot because nobody wants to sign them. It's a hard sell, but in certain circumstances, it can be very helpful to do that, to minimize your liability and the dollar value of your liability. The next one is alternative dispute resolution, or ADR. So that just means ways to settle this other than going to court. So the main two ways you hear about, arbitration and mediation. So arbitration, I think we're going to talk a little more about this later, but arbitration is it's usually binding. It's the most similar thing to going to court, but it's not public, it's private. It tends to be cheaper and tends to be faster, but not necessarily cheaper or faster. But one of the main benefits is that it's private and you don't have to air all of your stuff in public court. Mediation is generally not binding. It's a lot more informal. The goal is not so much about deciding who's right and who's wrong and what damages are, like arbitration and lawsuits will. Mediation is more about how can we come to a compromise that everybody's happy with so we can move forward without having to go to lawsuit. So these provisions have to be in the contract in order to make them binding, that you have to do mediation or arbitration before going to court or instead of going to court. So if you want that, you don't have to have it, but if you want it, it should be in the written contract. Confidentiality clauses and NDAs, we're going to talk about separately because they can be their own contract. Same thing with non-competes and non-solicits, we'll talk separately about, but sometimes those clauses can be directly into a contract as well. They can be in another contract or be their own. So some other quick common provisions we see, we call these the boilerplate provisions. They're kind of copy and pasted in legal language in almost every single contract. And they don't usually change a lot, but they can be important. And they can clarify things just in case, to kind of cover your bases is why we have it in here. So quickly, I'll just go through these. Assignment clause is just, it's saying, can I transfer my duties, and can you transfer your duties to somebody else? And if so, under what circumstances? So most of the time we'll see clauses that say, you can't assign this contract, it's just between us two. You can only assign it to someone else if I give you permission. So let's say I hire a consultant, I only want to work with that consultant, I don't want her to transfer it to somebody else. So we'll say this contract is not assignable by either party. Some circumstances it makes sense to be able to assign it. Sometimes we know that someone's a sole proprietorship now, but they're going to become an LLC. So we'll say you can't transfer this, except it'll be an automatic assignment from the sole prop to the LLC, for example. So we don't have to enter into a new contract once a new entity has been formed. Amendment is the next one. This usually just says, no, this contract can only be amended in writing, signed by both parties. We just want to make sure we don't accidentally change the provisions by having a conversation with each other. So, let's just say it has to be in writing and everyone agrees in writing to it. Otherwise, this contract is the only binding version. Severability clause means there's a clause that usually says, if this contract ends up in court, and if a judge decides that one provision in this contract is binding or is bad or needs to be changed, then the rest of the contract still stands. If we have to take out that one provision, we'll take out that one provision, but everything else is still in full force. It doesn't void the whole entire contract. A waiver clause usually says something along the lines of, if one party waives performance once, it doesn't mean we're waiving that thing for every other time going forward. So let's say I have a client who's supposed to give me 5 different payments in an installment payment. If they're late on the second one and I say, no big deal, I'm going to accept your late payment and we'll keep going, that doesn't mean that I'm waiving payment on time for all of the rest of the payments. They still have to pay on time for the rest of them, and I can choose not to accept late payment for the other ones. So it's really just trying to say if one party allows the other party to breach, you don't give up your right to enforce the contract later on. Notice is the next one that mostly just says, how do I contact you if I have to sue you? And what's the process for doing that? Governing law, jurisdiction, and venue are also really important, and they're different but similar. So governing law says, if this contract goes to court, what state's laws are we going to use? So we're in California, we're going to say California law applies. But theoretically, you could choose a different state's law. We won't get into the details of that, but generally, if you're performing in a state, use that state's law, and that's what's going to apply. Jurisdiction, the same. What jurisdiction means? What court am I going to be in? What court system has the right to decide? So generally, we're going to say the jurisdiction is, state courts in Northern California. Whatever district is going to apply, and who has the right to decide the case. Venue is the same. What actual court are we going to? I'm going to file this in Alameda County, for example. Force majeure. The purpose of this is to say that if circumstances happen that are completely beyond one of the parties' control, that person will not be liable for breach. So normally this is one of those ones I breeze right past because it doesn't come up a lot. But I think this, again, I bolded because I think we're going to see a lot of conversation about force majeure. Because, under what circumstances what circumstances make this provision apply? What has to happen in order for me not to be liable for breach? And if so, what are the consequences? So, if somebody paid for the services and I can't do the services, I might be off the hook for performance, but do I have to give them their money back? Probably, but it might depend on what the contract says. I think we're going to be seeing a lot of this, and it kind of puts a spotlight on how this provision can be really important and really helpful for people, because if you can't perform because of circumstances outside of your control, we don't want you to get sued for that. And so this is another opportunity. If you are having trouble with a contract right now, it might be worth looking at this clause, bringing it to attorney, seeing if you can get off the hook for this. So the next one is entire agreement. That just usually says, this is the entire agreement between the parties. Any other conversations we've had or drafts are not part of the contract. This is the contract, nothing else matters. Just again, to create clarity. Counterparts usually just says, if I sign a version and you print it out at home and sign a different version, both of them combined will be the contract, and we don't have to both sign the same exact piece of paper for it to be binding. Electronic delivery, I also always try to put in contracts too. That just says, and a digital signature counts as a signature, and it's okay for us to send this over DocuSign or whatever online means we're going to sign this. So there's, again, no ambiguity about whether you need a handwritten signature or not. All right, so those were some common provisions we see in a lot of contracts. The next section we're going to talk about here is negotiation and drafting. What is the actual process of negotiating a business contract and writing it? So one of the number one questions that comes up is, do we need a lawyer to draft this or not? It depends. Sometimes you might not need one. Sometimes having a lawyer makes things more contentious and makes people fight more and gets people really on edge because they're like, oh God, are they going to sue me? They're trying to be really serious and intimidating and I'm going to push back. It can take longer with lawyers, and it probably will be more expensive. But on the flip side, your interests are going to be protected. The lawyer's job is to make sure that everything is in there that needs to protect you. And they're going to help you decide what provisions are non-negotiable, what provisions are recommended, and what provisions maybe we can let go, which is the next bullet point here. So I think it depends on the contract. If it's something simple and everyone kind of agrees, then you probably don't need a lawyer for every little thing. But if you're buying and selling a business, have a lawyer do that. If you have a employment contract, I think it's good to have a lawyer do it. We'll give examples later, but the more complex it is, the more you should have a lawyer do it. But business contracts in general, I think, are not worth messing around with because you want to make sure your interests are covered. So it is helpful before you start negotiating to have a list of what's non-negotiable to you, what's I'd like to have, but I'm kind of willing to give it away if I have to, and what's in your pocket, able to give away, no problem, in exchange for something you do want. It's helpful to think about that ahead of time so you can go in with a clear head and it minimizes some of the back and forth. So you've probably heard people talk also about term sheets and memorandum of understanding. These are some documents that often are prepared before a written contract is entered into. So we see this a lot with buying and selling businesses, investing into startups, things like that. Complex things that take a little bit of negotiation. So these usually are not binding, but sometimes they are. It's usually more a document that's like, hey, you're going to invest in my business. I'm going to give you this and this and this. I'm going to give you this percentage. I'm going to give you priority payments back. And so you can be really clear about what that person is getting before they commit to giving you $100 grand or whatever it is. They want to know what they're getting, and you want to be clear what you're giving. So not required, but sometimes useful. And then your last decision is kind of what's the language we want to use. We have a lot of people who are consultants or have really small businesses, landscape design businesses or a tutoring business, and you don't want to have some 10-page long scary contract that people aren't going to read, and they're going to be like, I'm not signing this, I'm just getting some tutoring, or I'm just having a DJ come to do a gig at my party. I don't want to sign this huge thing. But at the same time, you still want to have your assets protected and your liability covered. So, you can still have a really good contract that's going to help you and protect you, and have it be a page or two long and really simple language. And so the language use and the length really should be adapted to the circumstances. And a good lawyer will understand that and be willing and adept at drafting a 1 or 2 page simple document for you if that's what you need, or the 20-page long, very detailed legalese kind of thing that's very specific and formal. So it depends on what you're doing, but think about what is appropriate in the circumstances. The next one here is kind of DIY contracts. So, I get a lot of people who have been using a contract they got online or got from a friend, and hopefully that hasn't caused them problems so far, but sometimes it does. And one of the also problems about doing a DIY contract is you get something online, and California law is very specific and very far-reaching, and California has some of the strictest laws from anywhere. So it's your online contract, your contract you got from a friend in Florida, probably doesn't cover your needs in California. So an example we see a lot, which is a dangerous one, is contractor relationships, where we were talking about the IP earlier, who owns the IP. So there will be a provision in there that says this is a work for hire, and therefore the IP is owned by the hiring person, not the creative person. But in every other state, that's great, that works. In California, a work for hire clause is a no-no, because a work for hire clause, the law says, makes that person an employee automatically. And I see these all the time, and I see lawyers drafting these all the time because they don't know this even. So be really careful, because it's very easy to make a mistake like that and then suddenly find yourself in a whole other mess, and you don't want that to happen to you. So be careful. So I highly recommend not drafting these contracts yourself. I have a friend who says using someone else's contract is like wearing someone else's underpants. I believe, a lot of these services online try to make one-size-fits-all documents, but the truth is that there's no one-size-fits-all. There's not even one-size-fits-most, because every business is different, every person is different, every contract is different, and it breaks my heart when I have people come to me too late and something's gone wrong and there's a provision in their contract that should have been in there that would have been if a lawyer had drafted it. So, again, risk is different depending on different situations, but I think it's a good idea to have lawyers do business-related contracts. Also, I want to tell people that something that surprises them a lot is it's often harder for a lawyer to try and fix your contract than to just do one from scratch, and therefore more expensive. So sometimes, we'll try to save money for people and say, sure, just bring me yours and we'll just update it. We'll review it and update it. But if it's a super messy contract, it's really hard for us to go through it and find all the things that aren't in there that should be there, and take out all the stuff that shouldn't be in there, and really change the language to make it fit to California law. It's hard work, and it takes a long time. And so that could take us 5 hours, whereas doing one from scratch, we already know where to start, and we already have tools that help us and the knowledge that helps us. So it might take us an hour to do a contract from scratch, and another half hour to go over with you, versus this back and forth trying to find everything. So don't be surprised. Don't feel like the lawyer's trying to rip you off if they're trying to sell you a new one instead of fixing yours. It legitimately might be cheaper for you to just have one from scratch. So I want everyone to understand that. So another question that'll come up is, if you're coming up with a contract between two parties, usually one party drafts it, the other party reviews it and makes changes, and you go back and forth a couple times. So one of the questions is, who should be in charge of drafting it? Because the party who drafts it usually has to pay more money because they're the ones spending more money on it. The drafting takes longer than reviewing and negotiating. So there are ways to make this work. So for example, if I'm drafting a contract for someone who's going to be a consultant, then they're just using it for a client contract, they're just going to pay it, and they're going to pay it once, and they're going to use that over and over again. But if there's two parties, one party's selling a business, one party's buying, let's say I'm representing seller, maybe there's a way to defray those costs and split it up a little bit, maybe adjust the price of the business by $1,000 or $2 to make it a little more fair. But so there are ways to kind of get around that, but you're going to need to decide who's burdening the cost and who's going to be responsible for drafting the first draft. Finally, I also do want to say it always takes longer than you think, even if everyone's getting along. There are just things you need to work out. There are things that need to be put in writing. There are always things that you hadn't talked about yet, that you didn't think about talking about yet, and suddenly we have to come to an agreement. So also don't be surprised if negotiation takes longer than you think it will, because it always does, because that's just the nature of these things. So just a heads up, especially if you're hiring a lawyer to do that. So that's the negotiation process. The next section I want to talk about is breach. What happens if a party cannot perform? So breach, what is it? It's just a failure to perform in the manner agreed to in the contract. So if one person breaches, the non-breaching party usually can collect remedies. So we'll talk about what some of those remedies are. But first, what exactly does breach look like? So the most common breaches I see in contract, like I said, the first one is usually a non-payment. You hired me to make a website, I made the website, you didn't pay me, and that's a breach of the contract, and I should be able to collect on that. Broken deadlines is the other most common one. You paid me to make a website, and I blew right past that. I was supposed to get it back to you by Friday, and I didn't. That's a breach of the contract. And another one that comes up a lot, especially in the Bay Area, is intellectual property ownership, especially when changing jobs. So let's say someone works for a very large tech company in the area, and they start their own business. What are they allowed to use or not use? Who owns what? Or even in small businesses, if somebody owns the business and leaves, what are they allowed to do? And what are they allowed to use, and what are they allowed to say? So what happens when breach happens? So the easiest way to handle a breach is to prevent the breach. So again, the more clear we are in our contract about what each party's responsibilities are, the less likely there will be a breach. But again, we want to see built-in consequences. A lot of times I'll see contracts that say, you do this and I'll do that, but it doesn't say what happens if someone doesn't, or if someone has to terminate early. And then someone does, and they're like, well, now what do we do? I don't know. So there needs to be specific laid out consequences about what happens in the different circumstances. There also should be a description of the remedies. So, this is the procedure for what happens if I breach, but what do you get? If I made half a website, I should get paid for that half a website, even if you don't want it anymore, because I did the work. So, but that needs to be put in writing. Otherwise, the person might say, no, I didn't get a website. I don't want to pay you anything. So, so that's why we need to be really clear. And then we can also be really specific about what those remedies are, because it's not just necessarily money. So we'll talk about that in a second. A description, again, of how to take legal action. So, again, what's the process? What do we do? Are we going to mediation? Are we doing arbitration? Are we suing? And go from there. And waiver is also another one. Again, we use the example, if I had an installment payment and they were late, I can choose this one time to say, we're good, just pay me now, and I'm going to waive that breach, and we're going to keep going. So it doesn't automatically mean it's the end of the world and this contract is over and we're suing each other. It can be an opportunity to keep talking, and I think that's a good place to start. How do we work this out before suing each other? You could also just say, you know what, we're good for it. Let's just stop, and I don't need anything else. So this is why a good contract is really important. It's, makes it really clear what might happen, and if that happens, what do we do, and how do we handle it? So remedies are just, what do you get if the other person breaches? Okay, so some common remedies we see: interest on late payments. So let's say I'm the web developer, you are going to pay me, but you're late. My contract says it incurs a X% interest for every day that goes by. So I theoretically can charge you interest, and that hopefully will incentivize you to pay me faster. Monetary damages. Usually, so this just means you pay me money to make me whole. So usually monetary damages replace monetary losses. So put me in the same position that I had been if I'd performed. So the web developer example might still be a good one. I lost money by doing this work for you without getting paid. Therefore, you have to pay me that amount that I lost. Or maybe I thought I was gonna paint your house for you, so I went out and bought a bunch of paint and supplies, and then you canceled, and now I'm out the money for all those supplies. I at least need to get paid back for the stuff I bought. So same position they would be if there'd been performance. And specific performance means forcing the person to do the thing instead of just paying me for it. So this usually, we don't see specific performance a lot. Usually it's money damages. But if money damages won't compensate, we can do specific performance. So let's say that I was buying this really valuable thing on eBay or something in an auction, and it's one of a kind, and I'm a collector. And in that case, if I don't get the thing, money is not going to do it. It was not just money. I wanted the thing, and that was the only thing of its kind. I might be able to do specific performance and force them to give me the thing. So questions to ask about remedies when you're actually drafting your contract. So one, are we going to give the person an opportunity to cure? Again, we already discussed that a little bit. Am I going to give them some leeway before I just go straight to the remedy? I think it's a good idea to have cure in there, just to give someone an option to fix it before you just burn the house down. But you don't have to, especially depending on the situation. The cure might not be appropriate. The next one is, what will actual loss be? So we like to be specific about what you're actually going to be losing if the person breaches, especially for things like confidentiality that are really hard to prove actual damages for. But it can be really damaging if someone spreads your secrets or uses your stuff without permission. So we can spell out what the loss will be and therefore what the remedy should be. Again, do we want to cap the amount of liability? We discussed this too. Do we want to say, I will be on the hook for up to X amount of dollars, and that's it. I'm not paying any more than that. Are there other methods to incentivize? So we already used the example of, I'm not giving you ownership of this IP until you pay me in full. Or incentivizing performance. Again, interest can be another one about that too. And again, do we want to put mediation and arbitration clauses in there to just minimize the risk of having to get to the point where we're suing someone for remedies. So what do you actually do if someone breaches? What's the process of actually enforcing? Because, you know, we can see easily when a contract has been breached and I'm owed money, but how do we actually get that money? So number one, first thing we would do is look at the contract. What does the contract say? Does it talk about termination? Does it talk about ability to cure? Does it talk about remedies and incentives? What are the enforcement provisions? Does it say what to do in there? So that's step number one. If it's not in there, there are also some just default rules in the law that we can look at. Number two, I think you should try to work it out. If you're ever not, if there's conflict, I don't encourage people to go straight to court. I think there's usually ways to come to some sort of agreement without suing each other. But sometimes that's not possible. So consider ADR. So whether or not, so sometimes ADR is required if it's required in the contract. Usually it's not. If it's not in the contract, it's not required, but it's optional. You can choose together to go to mediation or arbitration if you don't want to go to court. And finally, I think as a last resort, if you need to sue someone, you can sue someone. Sometimes you'll have to go to small claims court if it's not a large amount of money. If it's more, you'll go to regular civil court. The limits of small claims court are going to be different depending on your jurisdiction. So that's a question you can ask a lawyer or look up. But small claims court, generally no lawyers, faster, easier for you to do on your own. So, all right, now we know what a contract is and what's in it. What are some common types of contracts that I see happening in business all the time? So number one, non-compete agreements. So the state of California, you might know, it's actually almost always illegal to have a non-compete. So a non-compete basically says you, employee, worker, are not allowed to go work for our competitor or anyone in this industry in this area for the next X amount of years. So it's limiting somebody's ability to do a job that may or may not compete with the company that they're leaving. So these are legal in California only if basically an owner of a business leaves ownership, and you are allowed to give them certain limitations so they don't just open up shop across the street and steal all the clients of the business, right? But they have to be reasonable limitations. So we can say, all right, we're co-owners of a gym, you're leaving, you can open a gym, but you can't open a gym within 30 miles of this one for the next 3 years. You can do things like that, but it has to be limited in scope. It can't just be you can never open a gym in Alameda County ever again, or anywhere ever again. So we see that a lot when we're selling businesses. We always ask if there's going to be a non-compete in there. But generally, if you just have an employee leaving, almost can never have them sign a non-compete. Confidentiality and non-disclosure. We see these also a lot in the Bay Area. People have a lot of ideas that they're trying to sell each other, and they want to know that people aren't going to steal their ideas. Often it's in a contract that has a lot of other provisions, but they can be their own thing. Basically just says, this stuff is that I'm listing are considered confidential or proprietary, and you promise not to tell anybody this stuff, at least in the scope of this contract or for this period of time. So that can be really helpful in business relationships because you want to be able to do work with other companies, but not worry about them stealing your stuff and selling them or using it for your own gain. The next one, independent contractor agreement or client agreement. So we are doing a lot of these. First of all, just in the case when you're the contractor, so all of, our web developer example, our tutoring example, our consultant example, landscape designers, all of these people who have small businesses who are doing work for other people, we're going to draft client contracts for. And so that's just going to help protect you, the consultant, in potential conflicts with your clients, again, to make it really clear what you are going to do, what you're not going to do, and minimize your liability. So it can also be on the flip side, if I am a contractor for someone else, if a business is hiring me, or I'm subcontracting to someone else, then we're going to want an agreement to cover that as well. So they're very similar contracts, but kind of used in different contexts. But independent contractor classification is a big thing lately because the new rule AB5 that came out in California this year that made it harder to classify people as contractors. So we're doing a lot of written contracts because under certain exceptions to this rule, written contracts are now required. So check with a lawyer about that. If you are a contractor or work with contractors, you might need to get a written contract in place. But I think they're good to have anyway, anytime you are working with clients or working as a contractor or with contractors, because again, we're minimizing liability. In the HR realm, the contracts we do a lot are employment contracts. So that's not everybody has to have an employment contract, but we do a lot of them for kind of specific types of jobs. We see a lot of them for higher level management jobs, CEOs, managers, things like that, sometimes lawyers in a law firm. We also see them sometimes for nurse practitioners, other kind of managerial types or people with specific expertise that maybe just we want to negotiate special packages for them or build in benefits or build in time limits, things like that, or bonus packages, stuff like that, that are just kind of outside the norm of a normal kind of hourly job that most people have. We also do a lot of severance agreements. So a severance agreement happens when somebody's leaving, often against their own will, and the company can have a contract that says, I will give you extra money in exchange for you waiving your right to sue me for a bunch of things. So sometimes we see severance as just, I'm going to give you extra money so you're happier. But usually I don't recommend doing that. There should be, again, a something for a something. So usually it'll say, I'm going to give you an extra month's pay. You'll please waive your right to sue me for these certain things. So we can both just like go off in peace and not have to worry about it. There are a couple things you're not allowed to waive in a severance agreement, but we don't need to get into that. But it's just a very common kind of agreement we see when people are leaving companies, especially again with these executive type roles or people who have a contract, or people you think just might be higher risk to sue you. Might be a good idea to offer them severance. IP assignments we already kind of talked about, because if you're transferring ownership of IP, it needs to be done in writing. So it can be in a contract or it can be a separate contract. It can be I created this thing, I'm going to license it to you, or I'm going to give it to you. The terms should be in writing. And then there are a lot of internal documents we draft for people all the time. So operating agreements and bylaws. So these are the internal documents of an LLC or a corporation that are very important to have. Also, agreements between owners of a company. So buy-sell agreement is a contract that is, I think, the most important document you can have in your business if you have more than one owner. So I call this a business prenup, where it's really at the beginning of the relationship. Let's be really clear about what happens if one of us leaves for whatever reason. So if someone dies, if someone becomes disabled, if someone declares bankruptcy, if someone gets pushed out, if someone wants to retire or just is done and wants to leave, what do we do? What's the process? What circumstances can they do that? Are they allowed to sell their shares to someone else, and under what circumstances? And if they're leaving, and does the other person have to buy them back or just have the option to buy them back? And if so, how much are we going to pay them for it? Because that's going to be the biggest one too. The person who's leaving is going to have a much different impression of what the value of those shares are than the person who's staying. So let's decide all of that before there's conflict, because it's going to, again, really minimize. We don't need to then start negotiating and fighting. We already have it all written down, and we can say goodbye in peace, and we already know what to do. So that's a really important one. So if you have multiple partners, have some sort of written agreement that talks about that. Leases and subleases, I think, are also going to be talked about a lot coming up. So commercial leases are very different looking from just, apartment leases. And sometimes they're a couple pages long, and sometimes they're 70 pages long, and we see them a lot, and they usually can be negotiated a lot. And people don't often realize that they can negotiate commercial leases a lot. So if you are entering into a commercial lease, I think it is a good idea to talk to a lawyer, because usually you can get huge discounts negotiated, and you don't know that. But I think what's going to come up a lot is people unable to pay on their commercial leases right now because people aren't in business right now. So I think we're going to see a lot of negotiation. I think step one right now, if you can't pay your lease, talk to your landlord and see if they'll cut you a break, a deferment maybe, or a partial payment, or a payment plan, or something. But if that isn't going to work, I doubt that will work, frankly, because the landlords are going to be in the same position as you, trying to cut costs right now and having a hard time making money. But it's worth an ask. If they don't, then there are other sources of funds that you can talk to me about, or Eddie about, or Joe about, and we might be able to help you just match up with some resources to help cover your bills for now. But that's a little tangential. Just if we're getting back to contracts here, it's just a type of contract we see a lot. And finally, business purchases and sales, buying and selling a business. People try to do this without a contract or with a contract they found online. I highly recommend not doing that. I think it's very important to have a lawyer draft your stuff, because they're complex. Even in seemingly simple ones, these are complex no matter what they are. So it's worth the investment in having the sale go smoothly and having it be really clear. And related to that, promissory notes, we draft those a lot too. I think they're good to have a lawyer draft. This is just if someone's loaning someone else money for anything. It should be in writing, and it should be really clear what the terms are, because I have seen people draft their own. And one thing that happens a lot with promissory notes is, let's say I'm owed $10,000, $500 a month for the next couple of years. You default on one payment of $500. If there's no other provision saying otherwise in there, I can only collect the $500, not the rest of the $10,000. So I'd have to go to small claims court every single month. You don't pay me, and get $500 at a time, which no, thank you. And that can also be a problem if it's a really long term too, because there's statutes of limitations. I might only be able to collect a year's worth or 2 years worth, but maybe it's been 5 years where I didn't get paid. So a promissory note should have a clause in there that says, if you don't pay me, I can demand the whole payment all at once. So I can demand my whole $10,000 instead of $500 at a time. So that's an example of something I have seen go wrong, and we couldn't fix it because they just made a promissory note themselves. And there was nothing they could do. They had to choose to go to small claims court, and literally a year's worth of the payments they weren't even allowed to collect on, because the payments were already past statute of limitations. So it's a good idea to have a lawyer do that stuff. So last section here, just quickly, problems I see a lot in contracts without getting help. So surprisingly enough, people often will sign their contracts wrong. And so we see this mostly in LLCs. So someone will be an owner of an LLC, but they'll sign the contract with their personal name and not under the LLC as a representative of the LLC. So there have been cases where that alone has removed someone's limited liability, and the court allowed the person suing them to go after personal assets instead of just the LLC assets. It's a really big deal. So if you're an owner of an LLC, it's very important. The byline should say, the name of the company signed by your name, and then put, your title, president, CEO, whatever. So it's really clear that you're signing as a representative of the business and not for yourself, because you don't want to be on the hook. So again, we see a lot of contracts that have no termination clauses at all, or just very limited termination clauses. We see a lot of, surprising amount of very limited payment provisions, which is really unclear. I'm going to pay you this, but it doesn't say what happens if something goes wrong, or if they don't pay in time. Just lack of clarity again about what the obligations are. I could say I'm going to make you a website, but I think that means a 5-page website, and you think that means a 20-page website. We're going to have some fights going on. No IP ownership clauses. That's a really common one, which again can lead to tons of confusion and fighting, and also not addressing future work. So this is something that someone will have a contract once, but then do work for them over and over and over and over again. So does that contract still apply or not? It should. You can address that in your first contract, and have a lot less ambiguity. So we do have some time for questions. I don't see any questions in. So things that I or the other people on this call can help you with contract review in case of possible breaches. I know that that's probably going to be happening a lot. So if you need someone to look at a contract's termination clauses or force majeure clause in these weird times, we can do that. And the other thing here is leases too. We can look at those as well. There's also employee issues that are already starting to happen. If this isn't necessarily contract related, but if you are cutting back on hours, or you had to close your business because of a shelter in place, or health concerns, things like that, we can help you with what are your obligations to your employees, how do you get funding, what resources are there for your employees to make it through. If they're getting cut back on pay, are there resources for you available as a business owner to survive? All three of us hosting this call can help you with those things, so please reach out. We did get a question just asking if this recording is going to be available. It will. I'm going to put it up on my YouTube channel, and the co-hosts, Eddie and Joe, will also have the recording to spread. So however you found this, webinar, that resource will be blasting the video out as well. So yeah, thank you for showing up and participating, especially in these weird and difficult times. So last thing here, I have a link on this slide. I have an article page on my website where I am gathering resources related to the coronavirus, and specifically for employers. So this link is for employers. I think we're all getting bombarded with a lot of information right now, and it's hard. It's overwhelming and hard to sift through the useful information. So I'm trying to collect the useful things and put it all in one place for employers. And I'm going to try to keep that updated every day or two because things are changing so much. I'm going to do another one for employees for the same questions, but on their side. So stay tuned for that. But that's a good place to start. And we'll also be posting updates on our Facebook page and things like that. So you do have resources available right now. Here again is the contact information for StartSmall, ThinkBig and the LGBT Center in San Francisco. So unless there's any other questions right now, or unless Eddie or Joe want to chime in with anything else, know that we are all here as resources for contract related things or just this difficult time. So thanks everyone for participating. Eddie, did you want to chime in?
No, I don't have anything.
Okay. All right, great. Thank you, Eddie, so much for hosting this, and also Joe for co-hosting and inviting me. Joe, anything you wanted to add?
No, I think it's all covered.
Okay, thank you so much. Yes. Sorry,
one thing. Also, I know that Galia put some resources about COVID-19 on a link to her website, but StartSmall, ThinkBig's website also has some resources available. There's a banner at the top if you are dying for more and more information about it.
Excellent.
You can check there too.
Awesome. Thanks, Joe. And I'll just put that link on my blog as well too, so we can have everything in one place so people know to find you. So thanks everybody for showing up, and thanks Joe and Eddie again, and good luck to everybody. Stay healthy, and we'll get through it together, and we're here as a resource to help you. So thanks for watching, everyone. Have a good day.